All right, court is calling 2021 CR 7498, State of Texas versus Jacqueline C. Sanchez. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Karen Corby for Jacqueline Sanchez, defendant, Your Honor.
Are you Ms. Sanchez?
Yes, ma'am.
I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes.
Are you the same Jacqueline C. Sanchez who was placed on deferred adjudication in 2021
Yes.
CR 7498 for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on December 10th, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 2 on or about the 12th day of February 2024 in Bexar County, Texas. The defendant, Jacqueline C. Sanchez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
Your Honor, state waives all the violations.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? All right, you're whispering.
Yes, ma'am.
All right. Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Your Honor, is for 2 years TDC.
That is our proposed agreement, Your Honor.
All right, why should I give her the minimum? What has she done on probation?
Judge, I can tell you that she did complete drug court. Unfortunately, she kind of fell short in reentry court. She had tons and tons of negative UAs. She had been working really, really hard. I believe that the underlying offense was 7 grams, so I know it's 4,200, but it was closer to the 4 than it was a 200. And Judge, she does have, I think, 139 days in jail. She just really just wants to put this behind her and move on with her life. She tells me she's been working for 2 years at the Tower of Americas. She's hoping they'll keep her job open for her, depending upon how, if you follow the recommendation, how long it takes for her to parole. She's got a house that she bought. Her kids are living in it. They've been paying the rent. She's hoping that will sustain itself while she's gone. But Judge, she just wants to put this behind her and move on. But she did do a significant amount of work on this probation.
All right, do you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, you can lower your hand. State your name for the record.
Jacqueline C. Sanchez.
All right, why didn't you do well in drug court?
I'm sorry, what was that again?
Why did you not do well in felony drug court?
I didn't have the money to pay for the UAs, ma'am.
No, felony drug court usually will not remove you from their program because you can't pay UAs. Are you telling the court that you were removed from felony drug court because you couldn't pay for the UA?
And I had a relapse. I had drank 4 beers, ma'am. She actually graduated from drug court, I believe, and then she went to the reentry. So I think she completed drug court. So I don't think she had a problem doing drug court. I think it's when she got out.
So here's my question. Why did they remove you from their reentry program?
Because I drank 4 beers, ma'am, on the 23rd.
No, usually it's more than that because felony drug court usually understands relapses. Am I wrong in that? Did they not understand that you had a relapse?
They usually do, ma'am, but this time they felt like I played them.
What do you mean by they felt like you played them?
They felt like I was lying. I lied to them.
Okay. All right. Probation?
Judge, the note that was received from drug court.
Well, just 1 second. Any objections to probation giving me some insight in whether or not I should follow this agreement?
Okay. And also, they found on my phone that I was trying to get, methadone for a friend because he relapsed and he was trying to get clean, and that's what I was doing. And I had somebody else ask me I was looking for marijuana for somebody.
Wait a minute, what?
I was looking for marijuana for somebody. They asked me to look for it. They text me if I could find it, and I told them yeah, but I never got to doing that.
Oh, so now we're getting to the point. So you were in felony drug court in the reentry program and you were looking for drugs for other people.
Judge, I think she was looking for methadone and possibly marijuana. She's not, the perfect probationer, but that's what she told me, Judge. I don't think it was in.
I made a mistake, Judge. I'm sorry about that.
Nope, you made choices. They're not mistakes, they're choices. All right, is there anything else?
Judge, again, we just ask that you consider the fact that she did spend a lot of time in drug court. She has been straightforward with you, I believe. And ask you to follow the state's recommendation of 2 years TDC.
All right, and do you want me to hear from probation or no, counsel?
Sure. I
Yeah.
don't think my client's trying to hide anything, Judge.
Okay. Probation?
The information that was received from felony drug court was, she did finish the program successfully. However, during the aftercare portion, there were UA tests with positive ETG results, and a phone search was conducted and text messages revealed that he was communicating with negative contacts and negotiating the sale of illegal drugs.
Okay.
I did reach out to felony drug court to see if they would be willing to accept for that, and at this point, they are not.
All right, so this is what the court is going to do. As previously stated, the court is finding violation of condition number 6 true.
So I think it's in.
I'm sorry, number 2 true.
Yes.
Thank you. The violation of condition number 2, the court is finding that to be true. There's a $1,000 fine. Time and money were run concurrent. Was the $57 ever paid for the laboratory testing? Do you know if you ever paid that?
Drug court? Was it
Ah.
to drug court? Okay,
Oh.
no, I have not taken.
Okay. There should be $57 restitution to SAPD for laboratory testing. If you would like, I could have you referred to the therapeutic community. It doesn't increase your time at the prison. It's just something to hopefully help you maintain your sobriety.
Okay, I'll take that.
All right, therapeutic community. Court's going to sentence you to 6 years in prison and give you credit for any time served. Going to show you what's entitled trial court certification of defendants' rights to appeal. Did you review that with your attorney? Did you understand it? Did you review that with your attorney? Did you understand it? All right, did you review that document with your attorney? Did you understand it?
I'm just leaving it to me right now.
Okay.
I explained to you. So you have one of the documents. You understand?
All right, did you review that document with your attorney? Did you understand it?
Yes.
All right. Because this is not, I did not follow your proposed agreement with regards to sentencing. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Good luck to you. Even though you're going to the prison, if you get out of prison and you need help, you feel as though that's not being addressed, so you don't know who to contact, felony drug court is always available, okay?
Thank you.
Okay, thank you. Good luck to you. Court is calling, 2023 CR 1149, 2023 CR 11150, State of Texas versus Christopher Adam Rodriguez. Can I have parties announced for the record for the state
Allie Jackson.
defense?
Shannon Walker, Christopher Rodriguez.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, have you received all the discovery in each cause number and reviewed that discovery with your client?
I have.
Court will find that the state is in compliance with discovery. Are there any applications?
No applications, Your
All
Honor.
right. Mr. Rodriguez, in each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment in each cause number?
We do, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
No, Your Honor, we're waiving count 2 in each indictment and proceeding on count 1 and the habitual enhancements.
Any objection?
No objection, Your Honor.
Mr. Rodriguez, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them?
Yes.
In each cause number, you're charged with unlawfully carrying a weapon with a felony conviction. Normally, the range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the state is able to prove up the habitual allegation, then the range of punishment will be 25 years to 99 years or life with a possible fine up to $10,000. Did you understand?
Yes.
If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
A Ring door camera capturing the terror that a San Antonio man with a violent criminal history let loose on a Stone Oak neighborhood on Sunday.
The man banging on the back window of a door and threatening to start shooting if they didn't let him inside. And that's not all. Our Daniela Ibarra with the video and a frightened homeowner who watched it all unfold live.
This video gives Lisa Sin chills.
It still feels like a nightmare.
On Sunday, Sin watched on her phone as this man strolls up to her door, gun in hand. Her kids hid inside their Stone Oak home alone.
I was just praying that he wouldn't do anything to hurt my kids. Take my stuff. I don't care, but don't hurt my kids.
34-year-old Christopher Rodriguez is accused of terrorizing several neighbors in Summer Glen.
Actually, one of our neighbors picked him up in the back of his truck and took him outside of the community.
An incident report from the Bexar County Sheriff's Office says that neighbor drove Rodriguez to the nearby Canyon Springs golf course. The report says Rodriguez pulled a gun on the neighbor, telling him, quote, he had two choices and that neither of them were good. Rodriguez, who was out on parole, has a violent criminal history dating back more than 15 years. Just last week, BCSO began investigating after a woman accused Rodriguez of punching her while Rodriguez drove a car and then at the couple's apartment. Assaults, according to BCSO, that took place in front of a newborn baby. That same woman told deputies Rodriguez tortured and killed her cat in front of her in May.
This guy has a rap sheet a mile long. There's no reason why he should have been on the streets in the first place.
While Rodriguez is now in custody, Sin says her family struggles to feel safe.
We're all a little traumatized right now.
Daniela Ibarra, KSAT 12
Do you
News.
understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, has your client been able to provide you with any defense of those offenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was. He is.
Mr. Rodriguez, has anyone threatened you, forced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand?
Yes, ma'am, I did.
All right. According to the plea bargain agreement, state is proceeding on count 1 in each cause number. Punishments be assessed at 50 years in the prison. There are no applications. The cases will run concurrently. State will take in consideration 2023 CR 10985 and 2023 CR 10984. Did you understand that to be the plea?
There's actually one additional one, Your Honor.
Yes.
Left off 2023 CR 11151.
11151.
Yes, Judge.
Any objection to the court writing that in as a part of the plea bargain agreement, counsel?
No objection, Your Honor.
All right, and then the court will take in, then the agreement is also to take in consideration 2023 CR 11151. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review those paragraphs with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There have not been, Your Honor.
In each of the cause numbers outside the plea bargaining agreement, the state is requesting no contact with the complainants. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Okay. Then, and cause number 2023 CR 11149. How do you plead to count one?
No contest.
Into the enhancement allegations, how do you plead? True or not true?
True.
And the cause number ending in 2023 CR 11150 to count two, how do you plead?
No contest.
And to the enhancement, how do you plead?
True.
State, any evidence to support the defendants, please?
Yes, Your Honor, and each cause number of state offer states exhibit 1 with all attachments.
Any objection?
No objection, Your Honor.
Mr. Rodriguez, in each cause number, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and judgments, but most importantly, there will be no live testimony. Did you understand? All right. Any objection to the addition of a judgment and the waiver and consent to stipulation of testimony and stipulations in cause number 2023 CR 11150?
No objection, Your Honor.
In each cause number based upon states exhibits 1 and attachments in your plea are true, the court will find the enhancement true, and the court will find you guilty of count 1 in each cause number. Are you proceeding with sentencing?
You could, Your Honor.
Anything you wish to say on behalf of your client?
Only this, Your Honor, there's a, outside of the agreement, the no contact, there's a young lady by the name of Cassandra in the no contact that is Mr. Rodriguez's daughter. Chris loves his daughter very much and he would like to have contact with her. He understands he will no longer have contact with her mom, but his parents who are here sometimes act as a conduit between the two of them, Chris and his daughter. And certainly Chris does not want his daughter to ever think that he doesn't want to have contact with her or that he would agree to such a thing. So he does love her very much. He wants to be able to do things like send birthday cards to her, maybe through his mom, and keep in touch as best he can under the circumstances that he's going to be under, which are him being in TDC and his daughter being in a different state under the custody of her mom, who will not have contact with Mr. Rodriguez. So what we're asking for, Judge, is the very limited contact that might occur where Chris would send a birthday card to his mom would relay that to his daughter, that sort of thing, just so that Chris can have make sure that she knows that he certainly loves her very much and wants to be there for her, but obviously can't because of the circumstances of the sentence.
State.
Yes, Your Honor. In the case that was, one of the cases that was taken into consideration, the sexual assault, one of the counts in there was endangering the child was present during the alleged assault. The action happened with her on the bed. She is under the age of 4, and so at this time, we do not feel contact is appropriate, Your Honor.
All right. And that was
Cassandra, and then
an alleged sexual assault
it was
against.
sexual assault against her mother, and then one of the other counts in the indictment was for endangering a child.
And just for the court's edification, Your Honor, there's a lifetime protective order against for Mr. Rodriguez, not for Mr. Rodriguez, but where he is. I think the court understands she is the protected person. He is the excluded person. That's a lifetime protective order with the mom, but he did ask, and the state agreed under those civil circumstances that he could have contact with his daughter.
All right. Is there anything you wish to say?
It's just that I have a protective order in place with the mother of my children, Allison Harris. That's for life. I understand that and completely fine with abiding by that. I just don't see why I need to not be able to have contact with my daughter at all. for the rest of my life.
All right, so I've read the police reports, right? So I'm assuming that you love your daughter. Am I right in assuming that? And you would never want to do anything to hurt her. Hurting her mom is causing her emotional damage. Do you understand that?
Yes, ma'am.
And I don't know why when people go to prison, they expect for people to wait for them. Like nobody's obligated to wait for people when they go to prison. I mean, it's not like the movies where somebody's coming to see you every day at the prison and just waiting at the prison to pick you up and I'm going to be faithful to you. That rarely happens. There are consequences. When people make choices, sometimes the consequence is you go to prison and nobody's waiting for you. It's like, yeah, I'm done. Maybe if you get out and you start acting like an upstanding citizen, we can get back together. But guess what? I don't owe you any fidelity while you're in prison. So all of this started over the fact that you thought that she wasn't being faithful to you while you were in prison. And how long were you gone in prison?
This last time, ma'am?
Mhm.
2 years and 9 to 10 months.
All right, so why do people think that somebody should wait for them for 2 years? That's 2 years. And then when people are out of prison, usually they're not faithful, but they want somebody to be faithful for them in prison because technically they have to be faithful because there are no girls in here at the male prison unless they're guards, right? And then we want people to be faithful because we got to be faithful. So here's the thing. She can contact you if she chooses to contact you when she's of age. Right now, I'm not going to order contact. So as previously stated, in each case, I'm finding you guilty. I'm finding the enhancement true. Court is going to sentence you to 50 years in the prison, give you credit for any time served. Cases will run concurrently, take in consideration 2023 CR 10985, 2023 CR, this one, 2023 CR 10984, and 2023 CR 1151. Let me change that in here because it's not written correctly. There should be no contact with Allison Harris and no contact with Cassandra Rodriguez. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Rodriguez, I realize this is a lot of time. How old are you?
34, ma'am.
All right, you're 34. Here's the thing about having contact with children. At some point, she's going to grow up. Maybe you will get out of prison. You've learned something. You've gotten your life in order. And there's always room that people may have for forgiveness, right? But if you are not doing the right things, then people may not have forgiveness for you. So whether or not she forgives you and ultimately wants to have contact with her father, that'll be completely up to her. But you have to make the first step by doing what's right. You understand? All right. Good luck to you. Okay. You're welcome.
Thank you, Your Honor.
Thank you.
Excused?
Yes.